are the theories that justify the court in a conflict case to apply the foreign law instead of its own domestic or internal law. Some of the traditional theories in deciding whether to apply the local law or domestic law or the foreign law in a conflict case are the following. First, the theory of comity. Second, the vested right theory. Third, the theory of local law. Fourth, the theory of harmony of laws. And lastly, the theory of justice. The theory of comity. According to this theory, no foreign law would be allowed to operate in another state except by the Comity of Nations, the reciprocal courtesy which the members of the family of nations owe to one another. In the old case of Hilton versus Guyot, the U.S. Supreme Court defined comity as follows. Comity, in the legal sense, is neither a matter of absolute obligation on the one hand, nor of mere courtesy and goodwill upon the other, but it is the recognition which one state allows within its territory to the legislative, executive, or judicial acts of another nation, having due regard both to international duty and convenience and to the rights of its own citizens or of other persons who are under the protection of its laws. In the case of Hilton versus Guyot, a French citizen sued an American in a French court. Judgment was rendered in favor of the plaintiff French, who later filed an action in an American court to enforce the judgment. The American court found that the trial in the French court was fair and impartial, but even in such a case, French tribunals do not regard American decisions with finality, but they still review the latter's decisions on the merits. They are regarded merely as prima facie evidence of plaintiff's claim. Hence, the same effect should be given by American courts to French decisions on the principle of reciprocity. However, in a 1926 decision, the U.S. Court of Appeals of New York refused to apply the case of Hilton versus Guyot. In this case, an American sued the defendant French citizen for wrongful delivery of goods in an American court. The defendant set up the defense that the same matter was already decided in his favor in an earlier case filed by the American in a French court. The lower court refused to give effect to the earlier French decision on the theory of the old Hilton case. Reversing the lower court, the U.S. Supreme Court ruled that since it was the American who filed the earlier case with the French court wherein he lost, he could not later impeach said judgment against him on the principle of comity, which gives conclusiveness to the French decision and bars his subsequent action filed with an American court. The basis of comity was stated as the persuasiveness of the foreign judgment, not the principle of reciprocity as held in the old Hilton case. Thus, two principles have been given upon which the theory of comity rests: the comity based on reciprocity and the comity based on the persuasiveness of a foreign judgment. In our rules of procedure, we still follow the principle of reciprocity held in the old Hilton case, because our rules provide that the effect of a foreign judgment or final orders is presumptive evidence of a right as between the parties and their successors in interest by a subsequent title, and may be repelled by evidence of a want of jurisdiction, want of notice to the party, collusion, fraud, or clear mistake of law or fact. The vested rights theory. Under this theory, our courts enforce not the foreign law or foreign judgment, but the right or rights that have been vested under such law or judgment. Rights, once acquired under a foreign law or judgment, should be enforced regardless of where the suit for its enforcement was filed. Thus, the ideal of uniformity and predictability of results would be achieved. If a foreign law gives a person a right, the mere fact that the law of the forum does not give him a similar or the same right is no reason to refuse to help him get what belongs to him. The exception is if the foreign law is against the public policy of the forum. It is a principle of every civilized law that vested rights should be protected. This principle also discourages forum shopping. An example of the application of the vested rights theory is the American case of Gray versus Gray. In this case, Mrs. Gray filed an action in New Hampshire for damages against her husband, Mr. Gray, for personal injuries alleged to have been caused to her by the latter while driving from their home in New Hampshire to Maine, where the accident happened. In Maine, the spouses are barred from maintaining an action against each other. There is no such prohibition in New Hampshire. The American court ruled that foreign torts should be governed by the lex loci delicti commissi, a right having been created by the appropriate law. The recognition of its existence follows everywhere. The theory of local law. The adherents of this theory believe that we apply a foreign law not because it is foreign, but because our own law, by applying a similar rule, requires us to do so. Hence, it is as if the foreign law has become part of our own internal or domestic law. A good example of this theory is Article 16 of the new Civil Code, which requires us to apply the national law of the deceased in the matter of his testate or intestate succession. If the deceased was a Chinese, although his children are already Filipinos, we are required to apply Chinese law, not because it is the appropriate foreign law, but because our own civil code tells us to do so. The theory of harmony of laws. Under this theory, identical or similar problems should be given identical or similar solutions, thus resulting in harmony of laws. Certainty of solutions to the same or similar problems are of particular importance in areas where the parties are likely to think in advance of the legal consequences of their transactions. For example, transactions involving real property should be governed by the lex situs in the interest of certainty and uniformity of result. Similarly, a person's civil status must be governed by a single law for the sake of certainty. For example, whether a person is single or married. The applications of the same or similar solution also prevents the bad practice of forum shopping. The theory of justice. Since the purpose of all laws, including conflict of laws, is the dispensation of justice, the proper foreign law should be applied in order to attain this objective. The defect of this theory, however, is that different persons may have different ideas of what is just. Should we then leave the question to the different notions of fairness and justice? Now, there being many theories as to the proper choice of law that should be applied in each particular case, what then should be considered the right theory? In the words of the late Justice Edgardo T. Paras, it will be observed that the theories do not mutually exclude one another. Perhaps the truth may be found in their combination. Certainly, if the world is to progress in understanding and judgment, it must recognize this imperative postulate that sometimes we have to apply the proper foreign law because courtesy, convenience, and international duty so demand, because there are vested rights we cannot conceivably ignore, because all too often the foreign law has become part and parcel of our law, because identical situations should be resolved by identical remedies, irrespective of the forum, and finally, because to do otherwise may ultimately result in the negation of justice. Likewise, former Senator Salonga states that, in the absence of an applicable provision in the code or statute, the various theories should be examined and weighed as they bear on a given conflict's problem. No single theory contains the whole truth. No one approach is completely valid. As one author puts it, the policies behind all the theories have validity. This suggests that they are not entirely exclusive. Indeed, there may be a gain in using different theories at different places to make more readily apparent the change in policies deemed dominant as the situations vary.